Let's get started. Hey, everybody. Thank you for joining. I see a lot of repeat people on, maybe one or two new folks. Everybody is welcome. I am John Miller, the founding attorney of Rock Solid Law and Title, and been practicing independently for 30 years, which I'm really excited about celebrating this year. And we have brought on a new team member this week that I hope some of you will get the opportunity to meet in the near future. So the firm is expanding and life is good here at Rock Solid Law. Some of you know me personally, and I am an absolute nerd about baseball. I love soccer, and our kids play soccer, and my whole life is ruled by soccer, but the Atlanta Braves are my favorite team. And so I am both very, very excited by last night's victory over the Dodgers and also quite tired from having to stay up and watch the West Coast games. I'm holding in my hand a baseball that I keep in the office. I do have balls from the likes of Hank Aaron, Phil Niekro, Dale Murphy, all my old time heroes, as well as Maddox and Glavine. I don't have Schmaltz, but got a good baseball collection, and I just wanted to celebrate the Braves. That happens to be a ball signed right down here at the Jacksonville ballpark by Wes Helms, who played for Bobby Cox and then now is one of the managers in the Braves system, a rising star. Someday, Brian Snitker will retire. He's 50 years in baseball right now, and Wes Helms may be our next guy. Enough of that. I've got, I think, a fun subject today. It didn't quite have the sex appeal of the last session, which had the huge crowd, but is nonetheless really, really important to know on the estate planning side of your life. Just a quickie about Rock Solid Law. If you don't know us, we do real estate closings, title and escrow, both residential and commercial. And I love representing small businesses. In fact, my next consultation this morning is someone wanting to start a 501c3 nonprofit. So love working with our small business people. But candidly, the estate planning area is the one that we spend the most time with in our practice. And I love it because it, in my view, is in service to families and keeping families strong. Also helping people not pay any more taxes than is absolutely mandatory. So today is generally in the estate planning area. Now, I say fiduciary and you think, what? Right? So to help with the terminology today, we're going to go where else but to Disney. I want you to remember watching Mary Poppins with your kids. And the quote is, if you invest your tuppence wisely in the bank, safe and sound, soon that tuppence safely invested in the bank will compound, and you'll achieve that sense of conquest as your affluence expands in the hands of the directors who invest as propriety demands. Tuppence prudently, thriftily, frugally invested in the, to be specific, in the Fidelity Fiduciary Bank. You remember that scene where the kid wants to spend his tuppence to feed the birds, but the bankers come in and talk about Fidelity and Fiduciary Bank. So fiduciary is what we're going to talk about today. I think the only time I really hear the word used much is in investing terms, like the Disney song, or in lawsuits where a certain party to, say, a corporation has a fiduciary responsibility to someone else. So just as a baseline, we're going to go look at fiduciary at Webster's Bank, and it says of or relating to or involving a confidence of trust, such as held or founded in trust or confidence. Trust or confidence. It's funny, you can't even define fiduciary with talking about a trust. And of course, last wills and testaments and trusts like a living trust, a revocable inter vivos trust, are exactly the place where the fiduciary comes up in our practice. Further from Webster's, fiduciary relationships often concern money, but the word fiduciary does not in and of itself suggest financial matters. Rather, fiduciary applies to any situation in which one person justifiably places confidence and trust in someone else. Got that? One person placing confidence and trust in someone else. We're going to talk about that a bit this morning. And seeks that person's help or advice in some matter. It's exactly what fiduciaries are. They're the people that you trust and are going to help you with your estate plan. And we're going to identify the most common fiduciaries in an estate plan this morning. So 15 or 20 minutes from now, you will be completely armed with the knowledge of what a fiduciary is. And there will be no more paralysis by analysis, because I have found over time that people just freak out over something like the definition of a fiduciary or figuring out who all those people should be. The truth is, in almost every scenario, you're going to be able to replace that fiduciary if you no longer lose confidence in them. It's very common to have somebody say, you know what, that relationship's changed, or I no longer think that would be the best person for that specific fiduciary position. We amend it. And even in an irrevocable trust scenario, we reserve the right to replace trustees. So the fiduciaries can be replaced even in an irrevocable scenario, usually. Sometimes with effort, but almost always there is a path to that. So, for example, the attorney-client relationship is a fiduciary one. Very important. We owe our fiduciary to the client. We also owe a fiduciary to the lender in a real estate closing. That may help some of you identify that fiduciary. Because the client trusts the attorney to act in the best interest of the client at all times, right? So yes, we are running a for-profit business, but we're not allowed to make decisions for our best interest. And I would like to say that I am very proud that in the 30 years of this firm, I always make decisions in the best interest of the client. I will tell you that I do not believe that every member of the bar follows those parameters, but I promise you that we do. A fiduciary can also be used as a noun for the person who acts in a fiduciary capacity. My trustee is my fiduciary. Okay, I let the cat out of the bag a little bit and got ahead of the game there. The word is faithful to its origin. I love stuff like this. It comes from the Latin, fidere, which means to trust. On to trust, my friends. So in every estate plan that we do, whether will or trust-based, we create a document that looks like this on our computer. This we call our fiduciary spreadsheet. Now, I want to tell you there are a couple of things which do not require a fiduciary that are typically part of the package. Those are the written declaration to physician regarding life prolonging procedures. Some people refer to this as a living will. I think that, as you know, if you've been with me, is the worst term in the law, because it has absolutely nothing to do with living. It's about the treatment during your last illness. Then the other one is your organ donor form. Of course, you don't need a fiduciary. You just fill out the form, and that is not mandatory in any estate plan. However, I guess you've probably heard me say before, I have a cousin who has a child who is only alive due to the generosity of a donor family. And I feel very strongly about organ donorship. That doesn't mean that I will absolutely follow the client's wishes. If you don't believe in being one, I would not require you to be one. But I make the opportunity available at no cost to everybody that comes to see us. So let's talk about the various fiduciaries that are needed in a plan. They can be different for every document. In my 37-year experience, they are often the same people repetitively, although there are different considerations, and I might just throw in a word or two about those considerations as we go forward this morning. So at the highest level of your plan is the trust instrument itself. And you may have one or more trusts, and I can tell you that there are, as planning gets advanced, specific reasons that some trusts need different trustees. There are people that are ineligible to act as trustees. And I've recently found out, working with a family who had a very trusted person who was a Canadian citizen, that in most instances, almost all instances, I'll go out on a limb and say, you want to have a US citizen acting as the trustee of your trust so that your trust is subject to the laws of our country. All right. So the fiduciary number one, the trustee. Every trust must have a trustee. There's a grantor or settler, it can be called. There is a beneficiary. Sometimes they're the same people. And then there's the trustee, sometimes the same people. With a revocable trust during lifetime, most people act as their own trustees. Like if a couple puts together a trust, they're going to be the trustees, but they don't have to be. They could choose somebody else to do that. There's some practical reasons why it might be good to be during your lifetime, but that's something we discuss with each client. So the trustee is the person who will have the responsibility pursuant to the rules or way that we have written that trust agreement. The trustee will carry out the wishes of the grantor for the benefit of the beneficiary, right? There also should be named at least one successor trustee, a person who can serve if that first person isn't able to. So first for your thinking would be, you need a trustee and a successor trustee. This can be one person. It can be a committee of people. That committee can be permitted to act independent of one another, which I have some problems with, or can act only together. Now, my preference and my advice is that if you're going to go with a committee, you have an odd number. 3 is a good one, because if you leave 2 people equally in charge and they have to get each other's permission to do anything, you're setting up a problem for the future. Are there families that say my kids are just going to have to work it out? Absolutely, there are. My preference, however, is a single trustee or 3 trustees. Of course, in some instances, in bigger estates, it may be 5. They appoint a committee to carry out their wishes. So the trustee is the very first fiduciary that everyone needs to think about to act for you after you are either no longer alive or no longer able to handle it. So the trustee may be acting during your lifetime. For instance, if you have developed some dementia and just are not able to take care of business. There could be an instance where a trustee comes in and you recover and then you take back over. So there are all sorts of facts and details which can occur around this. After the trust, we want to talk about a will. Some estate plans do not have a trust and only have a will. And so in our state, Florida, we call the person that will be responsible for taking your will to the courthouse and presenting it to the judge and being appointed to carry out your wishes under the will, a personal representative. You may have heard me say in Florida, we wear flip-flops and we talk about our PR. Our northern neighbors often talk about the same position, the same fiduciary position as an executor, or in the event that it's a female person acting in that capacity, an executrix. Executor, executrix. I often know if a lawyer's primary practice is in a state other than Florida when I see those terms in a will. They are proper. There's nothing wrong with them, but it is not the terminology we most often see in Florida. So that fiduciary will have the burden of representing your estate before the court. And every estate which does not have a trust, and every estate in which the trust is created, but the assets are not transferred or funded into the trust, will go through the probate process before the court. And therefore, it is very important to choose the fiduciary that you think would best do that job. Now, I must point out that while weight will be given to the person you have chosen, ultimately, the judge decides who will be the personal representative of an estate. For instance, the person suggested is an ex-spouse and the children come forward and say they shouldn't serve. or the person suggested has developed some dementia or something or other incapacity of ability to serve, somebody else in the family may come forward and say, no, 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 they don't need to do it, I do. And basically, their lawyers would present that case to the judge, and the judge decides. Just one of the many reasons I like to keep matters out of probate, because nothing is certain when you go to the courthouse. With a trust and with a fully funded trust, you would not run into those issues. Now, a lot of people first come to see us to do their estate planning when they have children. And the declaration of guardian for a minor child is a document that we always include in an estate plan when there are minor children in the family. So a guardian is another fiduciary. This person will have the fiduciary responsibility to take care of the raising of your children if for some reason you were unable to do so. Now, a guardian obviously has some different parameters than the person that you might choose to be your trustee and certainly your personal representative, because a guardian is the person that needs to have parenting skills, someone that you would trust to raise your children, and probably in many instances trust to spend your estate wisely on your children and not on themselves. Now, many families say, look, if my sister's going to have to raise my kids, I want them to have the money to do it so that my kids aren't a burden on them. Totally respect that. We can totally do that. And you can either make the guardian the trustee in that instance or the beneficiary of an estate, or you can have a separate trustee who will be in charge of providing the money to the guardian for the health, welfare, etc. of the minor child. Moving on to the power of attorney. The durable family power of attorney, or indeed any power of attorney, appoints a person in a fiduciary capacity, a fiduciary, who will act as your attorney in fact. If you hear the term attorney in fact, that is not the same as attorney at law. An attorney in fact certainly does not have to be an attorney at law, although being an attorney at law does not automatically disqualify one from serving that capacity. So an attorney in fact is a person who is given the power of attorney by somebody to act on their behalf. 10 years ago now, wow, we had new laws in this state. So anybody whose power of attorney is over 10 years old or comes from another state really ought to have that updated. And because of this change in the law, which I believe there is a webinar on at our Rock Solid Law /videos website page, you can learn more about it. But the attorney in fact gets powers immediately. They're no longer springing. So it's very, very important to pick that fiduciary that you do have a trust and confidence in to do right by you. The great thing about having a power of attorney in effect is that should you lose your capacity, should you be in an accident, or should you develop a dementia, or, these days there's just a lot of Alzheimer's and, other diseases out there that are causing us to lose mental capacity, even as medicine is able to keep our physical bodies living longer. This means that having appointed this person, this means that having appointed this person, you will not go through a guardianship before the court to determine a guardian for you as an adult. There are good reasons to have a court-appointed guardian in certain scenarios, but for my clients, we don't want to leave that, because that has been called a living probate. You watch people fight over the control of you and your money in court to determine who's going to be in charge. You get rid of that entire thing with the power of attorney. A lot of times people think of a power of attorney, it is an ancillary document. You think of it as not as important as the other documents, but really, for those people that haven't had one and had to go through a guardianship, it could have been a heartbreak saver. Does that make sense? Yeah, I didn't go, but I heard Pat Benatar was great last night, and I'm sure she performed. You got it, heartbreaker. You're probably also thinking of Tom Petty right now. Got to work a little music into these things on Thursday mornings and keep us happy. All right, couple of more. While the attorney in fact who serves as the fiduciary under your power of attorney is responsible for your business things, your banking, your insurance, your mortgage, all those things. Your healthcare surrogate attorney, in fact, is in charge of dealing with your doctors, your nurses, your hospital staff, all of those people that might need to be advised of your position when you are unable to do so and you are under medical care. So the healthcare surrogate is really, really important. Appointing that fiduciary, that person that you trust to act for you in making those important medical decisions. And it's really important, by the way, that those be on file with at least your primary care physician, if not also at the hospital where you would most likely enter treatment. Really important that that document be taken to your doctor. All right, I've just got one more, so I'm going to encourage you to ask any questions in the chat bar now, because when I finish up, if there are any questions, I'll go back to doing some different work. Let's see. The last one that we really want to talk about today is the HIPAA release, and that goes right along with your healthcare surrogate. Now, with regard to a healthcare surrogate, you want to appoint a fiduciary who would probably be around and be available when you were undergoing healthcare, right? Healthcare issues. So we want to pick somebody who can be on the spot. Although with electronics now it's a little easier, but I'd still rather somebody be right there in person to take care of me, and an alternate, right? In case that person was on vacation or away or something, somebody else could step right in and be there for you. The HIPAA release is merely the document which allows people to get your medical records so that the healthcare surrogate can act appropriately on your behalf, because let's face it, even our closest friends and family don't know all of our medical history in all likelihood. So that is not restricted to one or two people. Most of these are not restricted, but practically only one or two are appointed. And many times we'll see a longer list of people who can, help out by going to collect the medical records. Of course, you'll want it to be only someone who you are comfortable viewing your medical history, right? But a lot of times I'll see families appoint a healthcare surrogate and then an alternate. And then when we get to the HIPAA release, we name all the other kids or other family members, so that somebody who just wants to help out actually has the ability to do so. Those are the primary 6 fiduciaries, people that are going to help you out, people you trust, people you have confidence in, that you will need to identify to properly prepare your estate plan. And it's not a big deal, but a little thinking in advance can really help folks out. So far, I'm still not seeing any questions, so I must just be a model of clarity and information this morning. I do want to let you know that in 2 weeks, we are going to have a course that you're all welcome to on financial abuse of elders and how it impacts real estate. That's going to be taught by Sue Dutcher, who's an expert in this. For any realtors, I see a couple on the call today, you can pick up 2 hours of continuing education. We're going to do that one in the afternoon. That's when our speaker was available on the 4th of November. And that will be at 1:00 p.m. So, financial abuse of elders is a really big issue, unfortunately, in our country. It makes me sick, but we see it happen, unfortunately, all the time. Predators trying to figure out ways to pry money away from our senior citizens. So we think that one was really important. We had scheduled the follow-up to this one, which is 6 estate planning must-haves, necessity of documents, where we'll run through the documents that are part of the package. Honestly, I think the planning is way more important than the documents themselves. When I meet with people, I want to know about their hopes, dreams, their values of and for their family, and then we help with the preparation of the correct documents. But people always want to know what the documents are. So I'm going to run through those at a subsequent webinar in December, but not on, I'm sorry, in November, but not on the 4th. The 4th will be financial abuse of elders and how it impacts real estate. I'm not seeing any questions, you guys. So I appreciate your attentiveness. I appreciate you being online. Now that you know everything that there is to know about the fiduciaries that you need for an estate plan, any of you that have already worked with us, and I see some on the call, we're happy to address those that you have chosen. Those of you that have not, of course, we would love to work with you, but you are armed with great knowledge for whoever you choose to work with on your estate planning. If you choose to work with us here at Rock Solid Law and Title, I will make that first consultation without charge so we can get to know each other and decide where we go forward. Scott, you are so welcome. Enjoy your day too. What a beautiful day. Another beautiful day in Northeast Florida. Aren't we lucky for where we live? I'm going to let the Commodores take you out. Zoom, everybody. Have a zooming and booming day. This is John Miller, founding attorney, Rock Solid Law and Title. And now you know everything you need to know about what a fiduciary is. Take care.